Thanks, Ian. And can I say I'm going to be a little bit more optimistic about the role of environmental law. And I'm going to do so by illustrating it with three brief stories about the formation of organisations. First, Ian referred to the formation of the first Environmental Law Association in this country, which was 78. A number of us came together with the encouragement of the ACF. They had put the newspaper ads and we had put an ad in the Law Institute Journal. I was still doing my articles then, and so it was the first year out of Monash. And we came together in the then Law Institute building, and it wasn't a big group, it was a small group of enthusiasts. But one of the issues in the agenda was what we'd call ourselves. And I had promoted it as a group of environmental lawyers were coming together to form this association. And in the front seat of the group was the then Dean of the Law Faculty at Melbourne University. And beside him was a more junior representative of the staff who eventually became another Dean of the Law Faculty at Melbourne University. Sounds like a story against Melbourne University rather than Monash. But the debate went this way. You can't possibly call your association Environmental Law Association, said the Dean. Because he said, there are too many people in our society, in Victoria in particular, who will oppose you and you'll never get anywhere. And the organisation will collapse and you will have failed your fine objectives. And he said it should be a Resource Law Association because in essence the environment is a resource. And can I give you the strongest advice as a very senior lawyer practicing in your field, he said, that you must make it resource law. And I responded and I said, look, to me the word resource implies an exploitable commodity. And to me we are all part, just a part of the environment. And if we set up an organisation that's called the Resource Law Association rather than Environmental Law Association, we are starting off on the wrong foot and we'll convey the wrong message and we will not be true to ourselves. And I said, look, and the debate ensued, and I said, look, I'm actually not going to continue if it's anything other than an environmental law body. And I won the day. And Melbourne University and that Dean and his successor never had anything to do with the then first 2 decades of the environmental law movement. A few years later, I had visited California. I went to the Sierra Legal Defence Fund, Sierra Club, and they had a sub-unit of environmental lawyers called the Sierra Club Legal Defence Fund. And I talked about this fantastic concept of precedent-setting public interest litigation to set the boundaries, push the boundaries of environmental law. And I said, look, we need that in Australia. So I packaged it up and brought it back, and we called it Environment Defender's Office as a concept. And at that stage, my environmental law section here at the Institute was a few years under the belt. And we got a summons from the Law Council of the Law Institute, the actual council, the governing body of the Law Institute here, we being me and a colleague, that the two of us behind this idea. And we were asked to appear in front of the full council of the Law Institute. And they said, look, we hear you want to set up this body called Environmental Defenders Office, Specialist Environmental Legal Centre. And I said, yes, it's a fantastic idea. And you know, there's a burgeoning new area of law and we should all be the cutting edge to develop the law. And they said, this council, this institute thinks it's contrary to the interests of legal practice in the state. And I was absolutely flabbergasted. In fact, I was almost speechless, and my good friend Kevin Zervos, who's now the chief prosecutor in Hong Kong, was furious, and he said, how can you possibly say that? And the president of the institute said, we believe that if you set up this somewhat aggressive appearance of an organisation, environmental law, the EDO, Environmental Defenders Office, you will take work away from the private sector in the fields that is, local government and planning, and that's in essence what you're talking about. You're going to take it away and create this troublesome body, and the Law Institute wants nothing to do with it. And they said, if you insist on proceeding, we will remove your funding for the environmental law section, and you can go it alone. Well, we were furious. The next week, I contacted some friends up in New South Wales, Michael Mobbs at the Sustainable House, Ben Boer, who was then a young tutor at Sydney Uni, and Murray Wilcox, who was then, I think, had just become silk at the Sydney Bar. And we went up to Sydney and we said, look, here's an idea. We'd like you to focus on this, because this is the attitude of the Victorian lawyers to setting up an EDO. And anyway, the long and short is New South Wales then took up that package, established the EDO, and I then had another go 3 years later or 2 years later, and the history will tell that we got an EDO in every state and territory and 2 in Queensland, and it's a fantastically effective organisation. It's had hundreds of precedent-setting cases. And the third story I'll tell was around about the same time. I was instructing solicitor for Bob Brown on the first dams case. There were 2 dams cases. The first one was against Fraser and Howard. Howard as Treasurer, Fraser as the PM for the Gordon Below Franklin scheme. And the first one took up to the High Court, and we weren't very successful, but it sort of laid the foundation of what was going to follow in litigation. Anyway, Bob came back to me about a year later. The government had whatever, the context had changed, and so the main dams case was now being put together in Tasmania, and they said, look, can we do this again? So I took it to the firm I was with. I was with one of the, then the second largest firm in the country, and it was based in Victoria, and I said to the firm, we've got this fantastic opportunity at this terrific case. It's a pro bono one, but it will change the course of Australian environmental law. And they took it to the partnership, and they resolved that it was contrary to the commercial interests of the firm, contrary to the commercial interests of the clients. And Simon, you are instructed to tell Bob Brown that we will have nothing to do with it. And so it went to Philip Fox, and I decided to cut loose and go to the bar. Now, if you think of those 3 stories, one is a perception within the legal profession that environment is a dirty word, that it is in the contrary to the interests of societal change, that it really should be deemed to be a resource issue, and resource is an acceptable term in the law. Another is about the management of the provision of legal services. Not that we stand impartially and give that advice to a client that deserves advice and support in major litigation, but no, we will be a filter before we accept that law, and say we won't actually act for that party. They can go elsewhere. They can go to a less significant firm that doesn't worry about their client base. And the other was the institutional prejudice that the Law Institute at that time had against setting up a community interest public litigation body that, as it's turned out, has swept the nation and provided thousands of good causes with a voice to be heard in the courts and tribunals around this country, the EDO. And I have to say, with every one of those sort of experiences, I've got to get very angry and more determined, and do not give up. And that's the message I say to you all, where you will be confronted with many, many obstacles if you want to pursue a career in environmental law.